Number 198, matter of Newcomb versus Middle Country Central School District.
Thank you, Your Honor. May it please the court, Paul Montori for the petitioner's appellants, Raymond Newcomb and Austin Newcomb. With me at counsel's table is Mr. William Berto. May I reserve 3 minutes, please, Your
3
Honor?
minutes, sir?
Yes.
You may.
Thank you, Your Honor. Your Honors, this case is exactly the type of case that the legislature envisioned was deserving of relief under GML 50E5 when the statute was amended to its present form in 1976.
What's our standard of review?
It's an abuse of discretion standard, Your Honor. And within that standard, certain factors need to be addressed within that standard to show that each factor in the record is looked at and analyzed in the totality of the circumstances, in the mix of circumstances that this court in Williams deemed so important. And I would submit that in this case, the lower courts abused their discretion by ignoring numerous factors in the record and improperly weighing each factor against the incapacitated minor Austin's application. And I believe the most helpful place to start, Your Honors, is with the prejudice determination.
Whose burden is it to prove prejudice?
And that's what I was going to address, Your Honor. I think that both parties can agree that the prejudice determination has become somewhat imprecise and loose over the course of time. And I believe the reason for that is because there's sometimes a failure to recognize how each factor relates to the other factor, and they tend to be compartmentalized. So I believe the best standard to implore, and I sort of look at it as a part one and a part two. The first part, as in any motion, any case, the petitioner bears a showing, must make a showing that for the petition to go forward is consistent with the statutory intent. Now, that showing can't be highly specific because we're at an early stage of the case. But once that showing is made, the burden of production and persuasion on the issue of prejudice falls squarely on the municipality.
So what's the showing?
Well, the showing, Your Honor, could be made in a few different ways. It could be made by showing there's a reasonable excuse. It could be made in showing that there's a short amount of time between when the incident occurred and when the late notice application is filed. It could be shown by actual knowledge. And in this case, I believe all those factors were in fact shown, but we also had the benefit of police pictures, which captured the scene precisely as it existed at the time of the accident. So perhaps that's certainly the only fortunate thing that happened at the night of the accident is the Suffolk Police Department was there and capturing the scene at the time of the accident.
But the statute lists those as 3 separate factors. It doesn't say that there has to be a showing or lack of a showing of substantial prejudice, and here's the factors you consider.
Right.
No, that's true, Your Honor, but I believe if it's looked at it in that way, it's best understood as to what kind of showing a petitioner needs to make. The petitioner needs to make that threshold showing to show that statutory intent is being fulfilled, and this is not a stale claim or a claim that is somehow incapable of being investigated by the municipality. Once that showing is made, then at that point is when the burden of production and persuasion on the substantial prejudice issue shifts over to the municipality.
So let's try it a different way. So what does that mean? What did the claimant here have to show to get past what you're calling, what it sounds like to me, some initial burden that then shifts, I guess, to the government?
Showing that, again, the statutory intent is preserved, that in fact this is not a stale claim, that in fact the ability to investigate the claim is in fact still available while information is still fresh. And all those things have been in fact shown, I believe in this case, through several different ways. Again, the police pictures being the most notable one. We also argue that in fact actual knowledge was present. The police report that is in the record shows the manner in which the accident happened, the time the accident happened, listing the witnesses that it happened. And I think there's another important point, Your Honors, that was overlooked in this determination, and that is irrespective of the debate that the parties may have with respect to actual knowledge, irrespective of that debate, the fact that the respondent in this case placed the sign and removed the sign also speaks to the prejudice issue, because it shows a complete ability to investigate the facts and circumstances as they existed, again, at the time of the accident. And I believe that's something that in fact, the lower courts also...
Aren't there other questions that could arise as to whether somebody had moved a sign or, you know, or...
Your Honor, that is information that is exclusively in the knowledge and purview of the district. And of course, the district, there's no evidence in the record that that happened, and when presumably, if in fact that there was evidence, it would have been put forward already in front of a special term. And there's simply no evidence of that case. And I think that in fact, Your Honor, is a theme of the error in this case, that Austin.
Well, would you agree that actual knowledge really is sort of a super factor here?
I believe it's also true, Your Honor, that the actual knowledge.
Well, I know what your position is on it, but my first question is, do you agree that influences the question of prejudice?
Certainly, and I think, Your Honor, the reason that actual knowledge has become important, and again, I would submit not because there's some magic words in the beginning of the statute. The reason we consider actual knowledge important is because, in fact, that's the gateway to the determination of if the statutory intent is preserved. When we have actual knowledge, we know, in fact, that most likely, not always, but most likely, there's not going to be substantial prejudice.
Tell me when there would be a situation in which there was not actual knowledge and there was not prejudice.
And the claim would be allowed to go forward in that case? I think that's the tough case, Your Honor, and I think I would first point to the law review article that we cited, which was written roughly around the same time as these things were happening with the statute with respect to when there is not actual knowledge, but when there's no prejudice, the strong inclination of the court is, in fact, to grant the petition. And I believe Your Honor is asking what happens when there is no actual knowledge and there is no prejudice. What may those other factors be?
Well, no, I guess what I'm asking you is when, give me some examples of when there would not be actual knowledge, but yet there would also not be prejudice.
I believe the best example that I can come up with about the tough case is, for example, if there's some sort of culpable conduct on the part of the petitioner, where there's perhaps no actual knowledge, but there's perhaps unclean hands where there's no prejudice, but the claim should not be allowed to continue. Besides that, I can.
But does that relate to prejudice, or does that relate to some other factor?
Well, I think that relates to the situation, Your Honor, where there's no actual knowledge and no prejudice, but perhaps the case shouldn't continue.
Okay,
Well,
I see.
isn't that why these are separate factors? Because government might not have actual knowledge, but all of the evidence is completely preserved and available.
And I think, Your Honor, in that case, the strong tendency is to grant the petition, simply because.
Because where's the prejudice when all of the, you're basically saying you had no actual knowledge, but you're in the same position you would have been if they had filed this in a timely fashion, because all of the evidence is still available to you. Using your language, stale, but evidence hasn't been destroyed, et cetera, and so forth. Isn't that the answer in part to Judge Stein's question?
I believe
That's why they're separate.
I believe that is.
elements.
I believe that is, Your Honor. There is an interrelation, but yet a distinct inquiry that needs to be taking place. And I see that my time is up.
Just to follow up on that, I always understood the statute to say this may be the kind of situation that we have here. This rare situation may be this case because there is no actual knowledge on the middle school district because they hadn't seen the photographs. They didn't know it. No one had linked them in it. And it wasn't until, I guess, you got full-size photographs in October, right? Mm-hmm. So in October, you got the full-size photographs. And at that point, that's when knowledge was available. And so the question is then, when that knowledge became available, was there prejudice to the other party? And so we're really left with the pure situation of no actual knowledge within 90 days. So the question then becomes, was there prejudice when the knowledge became available?
And certainly in this case, Your Honor, I think there's two answers to that question. The first part of it is there is actually language in the statute which addresses that particular situation, and that's actual knowledge within 90 days or a reasonable time thereafter. In this case, filing of the proposed notice of claim at the time it was filed actually provided actual knowledge within a reasonable time thereafter, because that's the only time when the petitioners were able to bring the claim to bear and to present the notice to the municipality. And with the second part of that inquiry, Your Honor, with respect to the prejudice, there was certainly no prejudice at this time when the actual notice was filed several months after the accident, and that's because in reality, the respondent was in a better position after that time was up. Had written notice just been available 91, shortly thereafter the accident, within the 90-day period. These are the precise type of pictures that the respondent would be looking for back right after the claim, and when they became available, the notice of claim was swiftly put forward.
Thank you, Mr. Montori. Ms. Gasser?
Good afternoon, Your Honors. May it please the Court. What is the standard of review? Abuse of discretion. I think in this case, this fits well within two courts taking very seriously the factors that the statute provides, applying it properly, and properly exercising its discretion to deny the application.
Didn't the two courts, the Nisi-Pruis court said that the respondent had the burden on prejudice, and the appellate division said the petitioner had the burden on prejudice. And your adversary says that they both had it, but the petitioner had a threshold burden, and then the burden shifted to respondent. So which do we discern that the appellate division thought?
Well, I think the Second Department clearly believes that the burden of proof as to prejudice rests with the claimant or petitioner.
That's the ultimate burden.
Yes, I mean, it's
And
clear.
that's different than the Supreme Court thought.
It is, and I would hesitate to say, but perhaps the Supreme Court hadn't looked at the Felice case when it said the burden was on the respondent to prove a lack of prejudice. I'm sorry, the existence of prejudice. Felice clearly said the burden is on the claimant to show that there will be no prejudice. But I think the way you do that, and there was much made of the prejudice issue, especially in one of the amicus briefs. I think it's pretty clear that you show the prejudice by showing or you show the lack of prejudice if you are the moving claimant by showing the actual knowledge.
I'm sorry, doesn't the statute say substantial prejudice?
Substantial prejudice.
So there
yes.
is an assumption there is obviously potentially some prejudice. So it's not that the standard is there should be absolutely no prejudice.
Well, the standard, the statute clearly says substantial
Right,
prejudice,
so it doesn't
absolutely.
mean that there is no prejudice. I just want to clarify, because you kept saying a lack of prejudice or showing prejudice. It's a quantified prejudice.
Yes, and prejudice is, in its nature, is difficult to show, but I think you go to why the statute is in place. It's in place, in some ways, as a protection for public corporations. I mean, I know that may not be liked by some folks or fashionable, but it's definitely meant to protect against the stale claims and maybe the ones that have no merit. And the merit in this case is of some significance, because we would contend that you can look at those pictures and pretty clearly see that sign had no impact where it was set back. I
But
think
that gets to the merits of it. I mean, we're
does.
talking about whether you're prejudiced or not. And so it's not like the plaintiff made no showing at all. The plaintiff came forward and said, look, we have these photos. The school district was responsible for placing and removing the signs, and they would have been in no better position if we had, because the signs were removed, the sign was removed, single sign, within 90 days of the accident. So the school district would have been in no better position had we moved within the 90 days. So no prejudice. Now, don't you have some obligation to come back and say, oh, but yes, we are, and to show why?
Well, I think the prejudice is because what does the statute hope to achieve? It gives you, as a municipal entity, the right in advance of litigation and in a very short time frame to get that there's something that happened that you did that had an impact
But now
and
you're
was
talking about
connected to
actual
injury.
knowledge. And I can't quite discern where you draw any line at all between actual knowledge and prejudice or substantial prejudice. Can you help me with that?
I think that the fact of the matter is, and the cases are, they're very consistent, no matter what verbiage is used. When you don't have the actual knowledge, and I don't think when it came that those photos were released, that was a reasonable time thereafter. When you do not have the actual knowledge, that's the essence of the prejudice. You had a
But
right
why
to...
would the statute have them separately enumerated and other factors as well. If it's all about actual knowledge, and that's the end of the inquiry, what's the rest of the statute about?
Well, but the cases seem to, in fact, treat it that way, because you have a large number of cases that say when there is no actual knowledge, they either don't deal with
Have we
prejudice.
treated it that way before?
I think in one sense, the Williams case versus Nassau County Medical Center, I think I would say that there was the very argument about whose burden of proof was it on the issue of prejudice. And in that case, the claimant was saying, well, no, the second department was wrong. It said we were responsible to prove a lack of substantial prejudice.
When you got the notice of claim, did you do a 50E?
A 50H hearing? Do you mean a hearing?
I think an E, but H.
I think we must have, Your Honor. I'm not sure.
I didn't see it in the record, and I would have thought that would have solved a lot of this. I mean, you would have asked them all kinds of questions about what happened, when, where, why.
You know,
And then decided this is all new to us, or the argument that frankly I thought made some sense, where you're saying it's meritless. I mean, there's no way the sign was in any way involved in this accident. But having not done that, we're stuck with this issue, aren't we?
but I have to say, Your Honor, I'm sorry, I didn't look at the file for that, but I do not believe there ever was, because absent a timely notice of claim or a
But you don't know
decision.
that. Well, I guess you know it, because in the notice of claim, they tell you what happened, but why not do a 50H?
Well, you just, with all due respect, you don't. It's not the common practice. If
Takes an hour and
there's-
a half.
Nonetheless, not done. It
Well,
would
it
be,
depends on where you are, I guess, because I know certain municipalities that do them automatically, and it would solve some of these problems.
well, we do them, in fact, regularly, but not if there's not if there's a denial of the late notice of
Ms.
claim
Gasser,
application.
What's the substantial prejudice to the district?
It's that a district is being asked here, having had no reason to believe that a random accident on a Saturday evening was connected to a sign that someone put at a corner. We'll assume it's the district. We don't know if it was moved, as Judge Stein said earlier. We are being asked to now defend a case, having lost months of an
Well, let me go back
opportunity
then.
to find out where the sign
I don't mean to interrupt
was.
you, but that's exactly why I was asking that question. I mean, you get a notice of claim, you have a right to bring that claimant in and depose them. And then you'd find out whatever you wanted to find out. But to ignore it and say, well, it's untimely, we'll ignore it. And then when they make a motion for late notice to say, well, we don't have the information, seems to me to be a little disingenuous. And I don't mean to put intent on that.
Yeah, well, but
wouldn't
Your
that have
Honor,
been easier?
that chronology, I think, is, that motion was in process, and the only hearing we would have had if we had chosen, and frankly, I don't believe it would have crossed our mind to do it because of the posture of the case. But it would have been of the dad.
Sure.
And he would
Yeah.
have known nothing about what was seen, what was there, what was not there.
Wouldn't that have helped you?
No, I think it would have been a wash, with all due respect. I don't think it would have helped us or hurt us. I think it would have been what it was, a hearing by a father who was going to be able to testify, maybe if he knew where his son had been, and maybe about the
I
injuries.
thought your issue was with whether there were witnesses and whether there were people involved in the placing and moving and whatever of the sign that you might have lost. So what does that have to do with whether the father or the child testified?
Right, but that, I just was responding to Judge Piggott's question. I mean, obviously, the question is what the district knew. Nothing about a 50H hearing would have assisted with
Usually
that.
when we say prejudice, we're talking about lost proof that isn't recoverable. What would it be here?
Well, you have a photograph, that's all you have, or a series
No,
of
my question is,
photographs.
how were you prejudiced? What proof did you lose access to? Usually that's what we're talking about.
Perhaps the students who could have been involved with the play, who might have put the sign up.
But that's
who
the
might have-
point, don't you have to come and show that, that these students are no longer available? So many people have graduated and,
Your Honor, I mean, I know that there are times that can be done, or that is done, but I think in a case such as this, I go back to Williams, where the claim was there was no prejudice demonstrated, and where this court basically said that because there was no actual knowledge, and that is an important and is an important factor in determining whether the defendant is substantially prejudiced. Those two things go together. This court pretty much
Do you have to,
piggybacks one on the other.
is your burden to show who put it up? I thought your argument is we didn't put it up.
Well,
That
you know,
within your control, and then you'd have to show that that evidence is no longer available to
the
you?
courts actually assumed we put it up, so we didn't get the benefit of any doubt there. There was an assumption that it was the district, it was a play that a school in the neighborhood had run. Having done that, this court, though, went on to say, we have no cause to disturb the appellate division's determination that defendants did not have actual knowledge. Accordingly, that court's finding of substantial prejudice was within its discretion. That's precisely the position that we really are asking the court to take today in this same case. It can be presumed that delays meant evidence or people's memories faded. It can be presumed that students moved on, maybe teachers moved on. But the district never had what the statute said it should have had, which was notice in that 90-day period or even a reasonable time thereafter. And 5 to 8 months thereafter was not a reasonable time. I think
You
this
see,
is...
that's my point. That could very well be prejudice. Whether it's substantial is another story. And that strikes me that the evidence of that is within your control.
And it would be but that wouldn't have been helped by a hearing, so I was responding to that. But I also go back to Judge Stein said, this actual knowledge is the super factor here. It's the thing to look at in particular.
But that's not the way the statute is written.
It is. It's the first sentence of the
Does
statute.
The statute has those three factors, correct?
Yes, but the first sentence of 50E, which is what sub 5, it says, in determining whether to grant the extension, the court shall consider, in particular, whether the public corporation or its attorney or insurance carrier acquired actual knowledge of the essential facts constituting the claim within the time specified. Then it goes on, the court shall also consider all other relevant facts. But I think it clearly elevated the actual knowledge standard above all other relevant facts.
Thank you, counsel. Mr. Montori?
Your Honors, I would just like to point to page 64, paragraph 15 of the record, and I think that's perhaps the single most important section in the lower court papers. And that is the only place in this record where there's even a brief mention of prejudice on the part of the respondent.
But when you look at, I thought, I was kind of struck by the merit or meritlessness of this, because, you know, when you finally get the police report, and you look at it, and you look at the pictures and everything else, you see where the plaintiff was and where the sign was and everything else, I'm wondering why you're chasing them. And it seems to me, and maybe you can tell me if this is right or wrong, whether you win or lose this, any one of the other defendants, because I assume you sued the drivers and
Yes, sir.
everybody else, they're going to bring them in anyway, aren't they?
Well, would be up to them. We presume that they will likely probably bring them in. But with respect to the merits, Judge Biggett, I would point first and foremost, well, of course, to the fact that we're not analyzing the merits, and that would be an extraordinary step. And in claims where it's this court and other courts have held patently meritless is the standard, that's normally done as a matter of law.
Going to that question, though, Judge Piggott's question on the merits in a different way, as I understand the timeline here, the sign's taken down before you file your late notice of claim?
That's
And you have photos. But isn't it, if they would have gotten this notice of claim while the sign was up, wouldn't you want to do a study of was it in the way? Could you see it if you have your expert come and look at the road and say, was that sign, where's the plaintiff, was it blocked? They can't do any of it now, and now they just have a photo. And you say, yes, they took the sign down, but they didn't have your notice of claim yet.
Well, Your Honor, I believe that the brief that respondent has filed itself has moved us towards the merits. We have the very definition of lack of substantial prejudice in this case.
But that goes to their ability to defend on the merits, not whether that study would have shown anything great for them, but prejudice to them in being able to defend this action because the scene has changed now. And if you had filed the notice within the time period specified, they could have had their photographers go out there, their experts go out there, and now they cannot do that.
Well, Your
right?
Honor, there is in fact no indication that the scene has changed.
The sign is down.
The sign is down, but again, that's something that they had the knowledge of when they took it down within the 90-day period.
But they didn't know you were suing them at that point, right?
Well, but Your Honor, in fact, there should have been at that point, we suggest, a possibility that they would be subject to claim. And we've pointed to the violations of the Town of Brookhaven Code that this sign does in fact represent. And in addition to that, the sign is a large
They
sign.
can't defend against that anymore either because the sign is down.
Well, the scene is capable of being reconstructed, Your Honor. That's certainly, I believe, true, by virtue of the signs, by virtue of the fact that they had the knowledge. And there's simply no indication of the record, only speculation from the lower court that certain students may have been graduated. I see that my time is up, Your Honor. May I just finish the point? There's simply speculation. And the fact is, also, I just would like to mention the incapacitation issue, and that when there is an incapacitation, there's a rich tradition within the Second Department and other departments that, in that case, the burden of showing substantial prejudice, irrespective of actual knowledge, does in fact rest with the municipality. And I can point to the Benson case, the Hague case, the DiMolfetto case. If that line of cases was followed, we simply wouldn't be in this position today. And in fact, this case is even more compelling.
Counsel, with Chief Judge's permission, could you respond to counsel's argument about the construction of that statute, that actual knowledge is the primary factor, everything else is secondary?
And again, Your Honor, I think it's to say it's the primary factor. It's the quick way to determine whether or not we get to having the statutory intent preserved. Because if we have that factor, the chances are most likely, again, not in every case, there could be certain scenarios like unclean hands that I mentioned on the part of the petitioner, where there's not going to be any prejudice, it's not going to be a stale claim, and there will be an opportunity to defend on the merits. But, of course, that's not the end of the inquiry. The inquiry goes substantially further than that, to the prejudice inquiry, to the inquiry of incapacitation, the ability to timely satisfy the statute. All of that goes into the mix. And in this particular mix of circumstances, I believe there's compelling evidence to suggest that the notice was filed as soon as it possibly could be filed. When the evidence became available, there was a criminal investigation which further hindered the cascading effects of the inability to satisfy the statute. So I believe that the actual knowledge piece, when we add the reasonable time component of that language, is certainly satisfied in this case. When we couple that with the pictures and the own knowledge of respondent, we get to a point where it's saying that this petition should have been granted, and it was abuse of discretion to ignore all of these different factors.
Thank you, counsel.
Thank you.